Good afternoon and welcome to the Five Stone Buildings webinar programme. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join us before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar programme. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join us before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar programme. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join us before we start. Whilst we are waiting for everybody to join us, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screens, and our speakers will try to come to those questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speakers do not identify you in their response. And just to remind you that this webinar is being recorded and will be available to view on our website shortly after the webinar has concluded. And I will now hand over to Elis, Gomer and Hugh Cumber.
Thank you very much, Joe, and welcome everybody. We're delighted that you're joining us for this seminar on adult-child claims under the Inheritance Act 1975. As Joe has said, I'm Elis Gomer. With me is Hugh Cumber, and we're both barristers here at Five Stone Buildings, specialising in contentious trusts and estates work, of which Inheritance Act work, both for claimants and defendants, occupies a significant part. As Joe has said, to deal very briefly with some housekeeping points, there is a Q&A box at the bottom of your Zoom browser. Do please put your questions into that, whether anonymously or not anonymously. We will make sure that there is time for questions at the end, though we probably won't be stopping during this talk for those. To add the usual disclaimer, the contents of this talk are not legal advice and shouldn't be relied on as such. And finally, it will be, as Joe has said, recorded and placed on YouTube shortly after the talk has ended. Those preliminaries out of the way, let me take you back to the 1st of April 1976, the day that the Inheritance Act 1975 came into force. Hugh and I were keen to do a talk on this subject because the Act is celebrating, if that is the right word, the 50th anniversary of its passing next year. Whilst an Act that's almost 50 years old is probably barely out of short trousers compared with some that we use day to day, like the Wills Act 1837, enough time has passed that the social context and the considerations for litigators that are involved in litigating these claims has changed very significantly. So the 1st of April 1976, the average wage is £72 a week, or £3,744 a year. The average house price is £12,704, or roughly 3.5 times the average wage. A pint of beer costs about 22 pence, and a loaf of bread is 19 pence. About half the population own a telephone, which obviously by that at that time meant a landline. Brotherhood of Man have just won the Eurovision Song Contest with Save Your Kisses for Me. The first commercial Concorde flight took off in January, and there's also a new Labour Prime Minister, James Callaghan, who took over after the previous Prime Minister exhausted himself talking about Europe. I can't imagine that happening today. So what do we as practitioners need to bear in mind? Well, the first thing, Hugh, is it's worth bearing in mind, isn't it, that the 1975 Act was not a new concept and didn't introduce a new regime of family provision, but was rather a development of an existing act based on a report by the Law Commission. So just dealing with that, what were the major changes that the Law Commission suggested?
Well, the first thing to note is that under English law, compared to some other jurisdictions, we have this general principle of testamentary freedom, which by the late 19th century had become well established and even extended to most of the population. So in 1938, Parliament was interfering with that under the 38 Act by allowing provision in some fairly limited classes, which are up there on the slide. And when we're looking about adult children, our topic today, the kinds of adult children who could bring a claim under that old regime were pretty limited, and they were classes which Parliament, through the lens of 1938, had viewed as likely to require maintenance from a deceased parent. So unmarried women, children of minors, of course, but in terms of adult children, only those who, due to some disability, were incapable of maintaining themselves. So that was the context in which the Law Commission came to revisit the categories of people who could bring a claim in 1975. And it's fair to say they took a fairly root and branch approach to reforming that and opened it up to every conceivable adult child. Now, it's not the only way they could have done it. In some ways, it's with the benefit of hindsight, perhaps unfortunate they didn't consider one of their alternative approaches, which was to limit it to people being actually maintained by the deceased, which of course is its own freestanding category of eligibility under the 1975 Act. There was a concern, and with the benefit of hindsight, a well-founded concern, that there would be no real limit on the kinds of adult children who could bring claims for reasonable financial provision. But the Law Commission decided that actually it would be up to judges to determine where the limits of the jurisdiction lay. And they thought, perhaps optimistically, this would be an easy task to distinguish between the deserving and the undeserving among those bringing claims under the Act. And they brought to that decision an assumption that it would be obvious that most adult children would be capable of looking after themselves and therefore need not trouble the court with claims following the death of their parents. But Elis, as you put there on the slide, it isn't the case that was met with universal accord when that was going through the legislative process.
No, it wasn't. And the point was made, and I think rightly so, that the Law Commission's proposals, in a way, were something of a contradiction in terms, in the sense that why would you open this up to a category of applicants who, in practice, probably shouldn't succeed anyway? And in those circumstances, there is the problem, which the Law Commission essentially said that they could deal with by saying, well, we will leave it up to judges to decide on a case-by-case basis, using this very broad set of powers in terms of eligibility, who is deserving or who should succeed and who should not, and that it was tidier all round to avoid putting the type of fetters that you've suggested in relation to them there. But what that has meant is that we have in the 1975 Act a set of powers that the court has, but really very little guidance, certainly statutory guidance, as to who should succeed and who shouldn't. And that type of lack of clarity is very obvious, I would suggest, in some of the early cases. So if we consider re Coventry, which is still probably a seminal case and is one that is frequently cited even today, it was the first adult-child claim to reach the court, and it was a case that failed. And what Mr. Justice Oliver, as he then said, was that in order to enable the court to interfere with and reform a testamentary disposition, it must be shown not that the deceased acted unreasonably, but that looked at objectively his disposition or lack of disposition produced an unreasonable result. And that's a different thing to saying it would be unreasonable not to make provision. He went on to say, here is the son of the deceased. He's in necessitous circumstances. There is property of the deceased which could be made available to assist him, but which is not available if the deceased's dispositions stand. Therefore, those dispositions do not make reasonable provision for the applicant. There must, as it seems to me, be established some sort of moral claim by the applicant to be maintained by the deceased or at the expense of the estate beyond the mere fact of a blood relationship. Some reason why it can be said that in the circumstances it is unreasonable that no greater provision was in fact made. Those words, moral claim, have been struggled with ever since. It was something that was obviously discussed in Ireland, which we'll come to in a moment, Hugh. But how do you react to the term moral claim, and what do you consider there to be some kind of easily digestible touchstone for what that means?
I think that it was what we saw there was the High Court grappling with a problem inherent in the category of adult children, that the only thing they have, by definition, is a blood relationship with the deceased. And an individual's view on what a blood relationship with a parent entitles you to is going to vary enormously from person to person. I'm sure that if we took a straw poll of the people on this call, their idea of what obligation a parent owes to a child out of minority would vary enormously, and it's effectively a political question and not one which the Act answers. So, in landing upon this phrase of a moral claim, I think what Mr. Justice Oliver was doing was identifying that it wasn't enough to have that blood relationship. Parliament has said, yes, you can bring a claim because you have that blood relationship, but that was never going to be enough by itself. So I think the idea of a blood relationship, which you see in that passage from Re Coventry, which you cited, really puts its finger on what the problem is here, that nobody really knows what it is a blood relationship entitles you to, if anything. I think there are some people who would view there is some sort of obligation to provide for your children on death. And equally, there are some people for whom the principle of testamentary freedom is paramount. And if they want to give it all to insert animal charity here, then that is entirely their prerogative. I feel quite strongly about that as well. And the fact there isn't one answer, and that includes among members of His Majesty's judiciary, really identifies the problem that the courts have grappled with ever since Re Coventry. And of course, as you're going to explain on the next slide, I mean, the discussion became about what does it mean to have a moral claim? What did Mr. Justice Oliver mean?
I've noticed that there are some people saying in the chat that Hugh's sound is cutting in and out. Okay. I don't know, Hugh, if you have a microphone that you can plug in, or if there's anything we can do about that. We'll do our best to resolve that.
I'll take a look at that now if you carry on with Re Hancock.
Certainly. Yes, so dealing with the question of the moral claim, the Court of Appeal said there that, and it's worth remembering that Mr. Justice Oliver in Coventry referred to maintenance in terms of financial provision, and that mirrored the previous legislation, the 1938 Act, which effectively, although it didn't say so in terms, referred to essentially the classes of applicant were people who were people that a parent might be expected to maintain financially. That was something that followed through in re Coventry. In re Hancock, it was said that it may be difficult for a child who is able to earn their own living to show that a reasonable financial provision has not been made for them without some special circumstances. And then Lord Hughes, again, putting it slightly differently, but it comes back to the same point. There is no requirement for a moral claim as a sine qua non for all applicants under the 1975 Act, and Mr. Justice Oliver did not impose one. He meant no more but no less than that in the case of a claimant adult son well capable of living independently, so different words, same essential point, something more than the qualifying relationship is needed to found a claim. And that in the case before him, the additional something could only be a moral claim. So what we have, one of the points which my personal view in relation to the Inheritance Act is that it is clearly not intended in the case of adult children to be a piece of legislation that says that purely by dint of there being an eligible relationship, that any adult child should be able to bring a claim. That so far so uncontroversial. Generally speaking, situations where it will be unreasonable for a testator not to have provided for an adult child either involve situations where there has been provision in life and therefore a failure to continue that provision in death might be seen to be unreasonable. I'm thinking, for example, of situations where an adult child is living in a property owned by the deceased, or where there has been financial contributions being made in life, or other similar situations, or where there are special factors justifying provisions. And there are some examples there. What could amount to a moral claim? Again, I have some difficulty with this term moral because it's an inherently subjective term. What might be moral to one person is not necessarily moral to another. But, for example, cases where there is a mental or physical disability, again, that was mirrored in the 1938 Act. Cases where, particularly interestingly, cases where the child has worked in a family business and is expected to inherit. See, for example, re Campbell, re Creaney, re Abram, you can see on the slide there. And there is a kind of parallel there in a way with proprietary estoppel claims. The kind of, albeit perhaps expressed somewhat differently, the sort of situation where there has been a one day my son, all this will be yours type situation, and where the will has failed to carry that into effect. Or, as in re Creaney, some other life event has intervened to mean that that hasn't happened. Good Child was a case where there was a failed mutual will agreement. And then Jennings, a case, again, certain parallels with proprietary estoppel claims where children have made personal sacrifices to care for an aged parent. So moral claims are inherently fact dependent, but it is important to bear in mind that they are largely edge cases. They are situations where you can see something's gone a bit wrong, I would suggest. So that brings us neatly on to Eilert and Mitson, a case which Hugh was obviously in. Hugh, I wonder how, obviously, I think we can turn to you for the actual meat of Eilert and Mitson in terms of where what we learn from the Supreme Court's decision. But perhaps if we start with the facts, I don't know if you've resolved your sound issues.
Well, that was what I was hoping to work out. I was wondering if perhaps if people are now able to hear me, if someone could put something in the Q&A to say so. I've fiddled with the settings to hopefully make it a bit more sensitive and a bit more clear.
Yeah, much better, thanks, Hugh.
Well, let's carry on like that and hope we don't run into any more problems. Oh, and I see a few people have said much better, much better. Okay, good. Well, fingers crossed that remains the case. Just before we move on from the previous slide, actually, Elis, just thinking about categories of claims that have succeeded in the past. Because I think we're about to talk about Elis, and it's a really important case, both on threshold and on quantum. But I think because of its very particular facts and which we're going to come on to, it can be easy to lose sight of those earlier cases where you have this element of promise, which wouldn't rise to the level of being an estoppel, something you mentioned, because of the lack of detrimental reliance, for example. But you do see in those early cases like Creaney, a moral obligation being recognised where a parent has caused a child to carry out their life with an expectation, put it that way, of benefiting from a parent. And I think perhaps what we see these days, increasingly, is children who have that expectation, but not necessarily through any acts of their parents, but rather a general expectation of an inheritance when the music finally stops. So I think it's interesting to look back at those cases. And another feature which perhaps we see increasingly in practice is that good child one, where a surviving parent may have inherited all of their wealth from their spouse, with a mutual expectation, even if it didn't rise to the level of being a mutual will, that on the death of the survivor it would be divided among the children, and then any one of a number of change of circumstances, not least a subsequent remarriage, could lead to that expectation that existed at the first death being thwarted. And so I think it's very interesting in those kind of multi-generational disputes to look at some of those older cases, those pre-Eilert cases, and see the situations where something rising to the level of something more, to use Lord Hugh's phrase, has been recognised. But yes, back to Eilert, sorry.
Yes. Well, perhaps if I just very briefly set out some facts in Eilert before we come to the section of it that you were involved with. Everyone, I suspect, will be very familiar with these facts, but Heather Eilert was 46 when the claim came to trial. She was the only daughter of Melita Jackson, the deceased, who left her entire estate, which was worth £485,000, to charity on the grounds that she was estranged from Heather. Heather and her family lived in straitened circumstances in rented accommodation, I think a council house, which was almost entirely financed through housing benefit and council tax benefit. They had been estranged since Heather left home to live with her then boyfriend, who she subsequently married. And her mother had effectively given her an ultimatum where she had essentially said, you can choose between a relationship with wastrel boyfriend, or you can choose a relationship with me. There had been attempts at reconciliation, but those had failed, and there had been a letter from the mother saying why she disinherited her daughter, which the district judge, the words he used were not wholly founded on truth. I suspect that what he means by that is that they were reflective of a slightly slanted approach to the facts. Another point which I should mention, which isn't on the slide, was that Heather's father had died when she was very young, and his estate had passed to the mother, which was also possibly a relevant point. She sought reasonable provision. Now, What that actually means we'll come to in a second, but it is relevant to note that both sides did not give the district judge the assistance he was probably entitled to at trial in terms of her case on quantum. Heather effectively set out a wish list in her claim, which, when you totted it all up, amounted to more money than was in the estate. The defendant said she should get nothing and effectively left it at that. There was no fallback position. District Judge Million, as he then was, heard the case over 2 days and awarded a lump sum of £50,000. We'll come back to that figure because I think it is very much obvious when you read the judgment. By the way, if none of the judgment isn't easy to find because it was heard in private, it's therefore the only judgment which is out there, which isn't in fact reported in this whole saga. It is clearly an extempore judgment. It is clearly somewhat rough around the edges. And I rather suspect that if District Judge Million had known that it was going to be subject to the full glare of appellate scrutiny, he might have tightened it up a little bit. But that takes us then to the appeals.
But sorry to cross across you, but before we move on from the first instance judgment, you mentioned quite rightly the lack of assistance that the district judge had. I would add to that what he really didn't have was any sort of explanation about the effect that an award would have on benefits, which became very important at the appellate level, as we're going to see. Yes. And I think that, as well as a legal argument on what an appropriate sort of award would be, some brief submissions on the kind of points that Heather later tried to run on appeal would have been greatly assistive to him, and may have avoided part of the whole saga that went on over the next 10 years.
Well, before we will turn to the appellate history, which is, as you point out, substantial. I note that there's a comment in the Q&A which suggests that the sound problem arises if you turn your head at all from straight onto the screen. If you keep looking at it, it should remain okay. So can I invite you, Hugh, to keep your head straight?
I will keep my head straight and look at my notes, which are over here out of the corner of my eye. Thanks, Elis.
Superb. So £50,000 from the district judge. The charities appealed saying that the charities, she should have got nothing. Heather appealed saying she should have got more. And a very significant thing happens before the first appeal judge, as she then was Mrs. Justice Eleanor King, namely that the time estimate was insufficient, and she therefore said, I'll deal with the appeal on threshold first, and I'll leave quantum over, because obviously if the appeal on threshold is allowed, it renders the quantum point moot. That becomes important later. But what she did was dismiss the appeal, allow the appeal, dismiss the claim, and say there was no good reason here to displace Mrs. Jackson's testamentary wishes. Heather appealed from there to a second appeal, and the Court of Appeal, first time round on the 31st of March 2011, said that and it's notable, incidentally, that that appeal took between the 1st of December 2009 and the 31st of March 2011 to come on, that actually there had been no jurisdiction for the appeal judge to intervene. The test isn't whether she would have done something different, but whether there was an arguable mistake of fact or law which rendered his decision wrong. They said there wasn't. He was properly directed on the law, no basis for the family division to intervene, and remitted the appeal to the family division to hear the quantum appeal. Turning then to that point, Heather's appeal was heard by Mrs. Justice Parker on the 3rd of March 2014, So just shy of 3 years later, that line about the wheels of justice grinding slowly, I think, was in full effect by this point. But she dismissed the appeal and upheld the trial decision again on similar grounds. And that takes us on to the Court of Appeal's decision on the 27th of July 2015. Hugh, I don't know if you'd like to pick up the story at this point.
Yes, so by this stage, you'll recall that we've had various awards ranging from £50,000 from the district judge, nothing on appeal to the High Court, and then a subsequent review. And can I just check? Can you hear me? Okay, Elis, is this all right now?
I think you're still dropping slightly. If you can.
I don't want to cause any problems for everyone if I'm having this technical difficulty. I think I've moved the microphone as close to my face as I sensibly can. But hopefully it's a bit clearer now.
I can hear you fairly clearly at the moment, certainly.
So, by the time we reached the Court of Appeal for the second time in 2015, this argument, which had been developed at various stages by Heather, that £50,000 was worse than nothing for her because it would deprive her of means-tested state benefits to which she was entitled, notably housing benefit and council tax benefit, had been fully developed. And it found success before the Court of Appeal, and particularly before Lady Justice Arden, who greatly took this argument on board and made a very significant award of £143,000 to allow her to buy the house that she needed, the house that she lived in, with the benefit of a discount, I should say. And the logic behind that award was that only an award which permitted her to buy her house outright and therefore replace the need for housing benefit would be sufficient to meet her reasonable financial needs, and any award, the logic ran, that did less than that would not be meeting the criteria of making reasonable financial provision because of the impact it would have on her means-tested state benefits. And that was the point at which I became involved as junior for Penelope Reid, QC as she then was, KC now, because the charities decided to appeal that decision to the Supreme Court. And that's what leads us to the appeal before a 7-strong Supreme Court, which, due to that unusual case history that Elis has explained, was limited to the issue of quantum. It was an appeal on quantum only because it was no longer open to the charities to argue their maximalist position that she should get nothing at all. That issue had been determined by the Court of Appeal the first time round, and no further appeal against that decision was available to the charities.
It's relevant to note, isn't it? And I certainly remember practice in this area between the Court of Appeal's decision and the Supreme Court's decision. There were a lot of claimants whose effective case on financial need was Eilert says I get a house. And I don't think it can be overestimated how much of a difference it made to the landscape, even though I don't think anyone could really argue that the Court of Appeal's decision was anything other than a decision on its own facts. But
well, there is one aspect about the Court of Appeal's decision that I think in some quarters was received as saying charitable defendants have no needs. Lady Justice Arden said something similar to that in her judgment, and therefore they are a very soft target. They're often residuary beneficiaries of estates, and they were therefore seen, wrongly in my view, but as a result of the Court of Appeal's decision, as a very soft target for claims under the Act, because you had this authority that the claimants could point to saying, look, they don't need anything, so we can effectively go to town on their share of the estate and they wouldn't be able to mount any sort of defence to it. So that was an important part in terms of the sort of floodgates argument following the decision of the Court of Appeal, that particularly these sort of charitable defendants, and perhaps to a lesser extent to individual defendants who were financially self-sufficient, that it was seen that anybody who could assert a need against a defendant who had no need had a really strong claim. I think that was the shorthand, that version of Eilert that became perhaps quite widespread, and caused some consternation for defendants.
Yes. So the Supreme Court handed down its decision on the 15th of March 2017, about 2 months shy of 10 years after the trial, and they reinstated the district judge's decision.
It's one aspect of the case that formed a major part of the charities case before the Supreme Court, and thankfully made its way into Lord Hughes's leading judgment, with which the other members of the 7-strong panel agreed, was the importance of testamentary wishes as a factor in the court's discretion. Because, as those familiar with the Act will know, there's this long list of matters under Section 3 which the court is directed to take into account. And what was being argued on the charity's behalf was that a conscious decision to benefit one potential beneficiary rather than another, to dispose of one's estate in a particular way, was something which was a freestanding factor which should be given weight. And I think that is something which Lord Hughes was prepared to take into account. Now, it's of course right that any successful claim under the Act will override testamentary freedom to some extent. So I don't want to overstate the importance of this point. But it's as a consequence of the decision that freely made testamentary choice embodied in a will, which was particularly important for the deceased in Eilert and Mitson, because she so didn't want to benefit her daughter at all. Whatever the rights and wrongs behind that letter, it was clear what her intentions were. And that finds its way into the decision of Lord Hughes for the majority. And in some ways, it's quite a narrow decision. Despite all of the explanation that comes out in that judgment of Lord Hughes, if you take its ratio, the ratio is probably that there wasn't sufficient grounds for an appellate court to interfere with the exercise of discretion carried out by District Judge Millian. And that was partly a product of the way the appeal came about, where the charities had one hand tied behind their back and could only argue for either a much lesser award than the Court of Appeal had been willing to make, or the District Judge's £50,000 award, which, as Elis has pointed out already, was the product of an extempore judgment, not greatly assisted by legal submissions.
Yes. So, where are we now? There is a much higher number of claims under the Act being made as part of a significant increase in estates disputes generally. That not terribly attractive graph there is number of probate cases over the first 9 months of the year from HMCTS. And you'll see that the trend is inexorably upwards. And obviously that is probate cases as properly defined. And it is only a small fraction of the number of litigated estates. I think perhaps the more relevant statistic is that there are in excess of 10,000 caveats entered every year now. And certainly anecdotally, adult child claims are a large percentage of that. There are a number of reasons for that. As Hugh has already alluded, more complex families, bigger estates in general, the boomer generation that is currently passing on are the first generation to own property in anything like the percentage they've owned it now, and also, as we've seen based on the figures I read out earlier, the number of, or the value of those properties has increased hugely. There is also, of course, the availability of CFA funding, which is something which hasn't been the case until, comparatively speaking, quite recently. I would suggest that the majority of the historic authorities are authorities which were either privately funded or, probably more likely, brought under legal aid, which had a means test and also a merits test. So there was going to be a fairly significant filter on claims being brought, compared with now, where, as we know, there are a number of drivers that a disappointed adult child beneficiary might choose or might have as a reason to bring a claim. CFA funding is available, so if you can find a claimant firm who will take your claim on, the risk, the financial risk, or the financial commitment is comparatively minimal up front. If the estate is substantial, there is likely to be significant pressure on a defendant to at least make some offer on the basis that they're not going to get their costs back from an indigent claimant if they lose. And also, there is, I think, and Hugh may expand on this, a sense that many claimants have. Certainly, I would say that I've seen a number of cases where there is a very strong sense that it was wrong for a parent not to make provision for perhaps a child if siblings were benefiting. That there is no more likely way to cause a fallout between siblings than disinheriting one of them over the others, for example. And also, increasingly, I think people rely on these inheritances. People say, this is how I'm getting on the housing ladder, this is how I'm going to afford a pension, etc. So all of those things coalesce to create a climate in which these claims are brought much more readily.
I think that's absolutely right. And I mean, one factor that one sometimes sees is a parent with all the best intentions thinks one of my darling children is rather irresponsible with money. They have a gambling problem or whatever, and I'm therefore going to put this nice discretionary trust into my will and trust my executors and trustees to do the right thing by this child. Well, I've seen a lot of claims where the claimant who's a beneficiary of the discretionary trust is jumping up and down and saying, well, that's not good enough. I can't trust this trustees to do the right thing by me. I need money in my hand. And I think even without the kind of encouragement from a parent that one might see in some of those earlier cases we mentioned earlier on in the talk, many children, and I mean these are children who, some of whom are pensioners themselves, I mean these claimants have an expectation of inheritance from a parent, even without any sort of encouragement by the parent. And when that expectation is disappointed, in some ways they've already spent the money in their head and therefore come up with a list of needs that they have that now need to be met out of the estate. And when that's coupled with a bit of good old-fashioned sibling rivalry or a perception that one child is preferred, which these types of wills can tend to encourage, it's the recipe for unhappy family litigation, often over what are, compared to the costs of litigation, relatively small estates.
Your sound was dropping out slightly for me there. Yes, and I think also, compared with some of those cases that we were talking about earlier, where you can say that there's something, calling it quasi-proprietary estoppel is a dreadfully imprecise way of putting it, but that kind of, I have a targeted financial need which has been brought about by reason of this state of affairs, which I expected to be continued or carried into effect, not being carried into effect. I would suggest that there is a significant constituency of claimants, which I've summarised on the slide there, which might be seen as a slightly typical contemporary Inheritance Act claimant, who you might describe as their financial need effectively can be summarised as, I haven't got enough money. And it's not I was being provided with financial maintenance, or I was being provided with a property. It is, I have a financial deficit on a monthly basis because I don't make enough money, whether from benefits or from employment, to fund my day-to-day living. I have some level of physical or mental impairment, and it's very common, I would suggest, to see these witness statements nowadays, which under that section of when you do the run through of the section 3 factors, there is, I suffer from anxiety and depression. Now, I am not for a moment suggesting that those things are not capable of being a disability or a physical or mental impairment, but it tends to be something which is not really evidenced by medical evidence, for example. It tends to be something which is asserted. And it's in the same way that it's rare to find a claimant in a road traffic whiplash case who hasn't been prevented from going to the gym by their accident. It's similar that it similarly seems to be something which is mentioned very readily these days, that the claimant suffers from anxiety, depression, or some other mental condition. And also, and I want to expand on this slightly, the long-term estrangement. And I would suggest, Hugh, that a pervasive misconception that's arisen as a result of ILAT is this tendency for claimants, it's become almost part of the idiom of these claims now, that claimants will say something along the lines of, I have been, my relationship with my parent was good, therefore there was no reason for them not to make financial provision for me. In the alternative, if I'm wrong about that, if I was estranged from them, that wasn't my fault, it was theirs. And I would suggest that is a misunderstanding of what ILAT really has to tell us about this. If it has anything specific it should be telling us at all.
Yes, I agree completely, because for me, what's significant about the estrangement in ILAT is not the reasons for it, which there will always be two sides of every story, not the reason for it, but the facts of the estrangement. Because in the case of an adult child in the sort of re-Coventry mould, most adult children are completely financially independent from their parents. And that factor will only be more present in the case of an estrangement. Adults don't typically expect large financial gifts, let alone maintenance, from an elderly or older parent. And so I think what's important about the estrangement in ILAT is that it demonstrated the complete lack of any ongoing financial relationship between the deceased and the claimant. And that will be equally true in many cases of the sort you're describing there, Elis, where it isn't anybody's fault. It's just everyone getting on with their lives. You know, you go off, you start, in some cases you start a family, you set yourself up in life, whether successfully or unsuccessfully. And it isn't, apart from seeing people at Christmas and birthdays, even in a normal relationship between parents and children, and without any kind of problems, there isn't that kind of financial connection. And that's what we're talking about here, reasonable financial provision for maintenance. And so I think it's a mistake, actually, to try and litigate relationships with parents in that way, except in a very clear case of bad behaviour by a parent, which might thwart an earlier expectation, the kind of estoppel case. To go into why you didn't see them every Christmas, for example, in your witness statement, because I don't think the judge is going to be very interested, and I don't think it's relevant to the issue that the court has to decide.
It's quite common, isn't it, to see a claimant almost parade a series of birthday cards and Christmas cards as evidence of the lack of an estrangement. But how do we tell the good claims from the bad? One point that I wanted to dwell on quite significantly in relation to this, beyond the fairly obvious starting point that a claimant must make out a substantial case for any change in the testamentary dispositions, is in relation to financial need, because it is a hugely important part of these claims. And it tends to be something which is commonly rendered somewhat formulaic, in the sense that you will get one of these tables. I don't know what the hand movement was supposed to convey there, but you'll get one of these tables which sets out monthly expenses, mortgage, food, utilities, etc., etc., and then this is how much I make every month, and the expenses figure is bigger than the income figure, therefore I have a financial need. I would suggest that that isn't sufficient by itself. And I would also make the point that the need to be clear about finances doesn't end with demonstrating and evidencing a financial need. It's also important to be coherent and clear about what it is that the claimant is seeking to achieve by their claim. It's very common, I would suggest, to find claimants saying that what they're after is reasonable financial provision. And if you ask the question, well, what do you say that is? They will either refuse to answer or not be able to provide a coherent response, in as much as they will say, well, I want the remedy I'm seeking is reasonable financial provision. But there is no attempt to be specific about what financial problem, as it were, they're expecting the court to fix. Is that something you've come across?
I think it is something one sees increasingly commonly, that even at a pre-action stage and then in the evidence, for defendants to complain that there's been a lack of quantification of the claimant's claim. And I think while it might be reasonable to say, obviously the court has a range of things it can do, ranging from the very generous to the very ungenerous, if I can put it that way. And obviously, those active claimants are going to put cases at their most rosy and optimistic. Despite that, it is important to identify clearly what it is you say this estate can do. Does it have sufficient liquidity to make large lump sums? And if not, how do you propose that that large lump sum would be met? Conversely, if it is property needed to meet liabilities and is an expectation to receive actually on analysis unrealistic or unachievable. I think sometimes, and we saw a bit of this in our run through the earlier cases, there is a difficulty where claimants lose sight on what the debts and tax have been paid actually is, because that's the very most the court can do for them. So while I think it's not always going to be the case that a claimant will be able to quantify the claim out of the last penny, it would be a mistake as a claimant not to be able to put forward a plausible case for what a good claim for them would look like.
Yes. I think some people struggle to hear parts of that, but it's very important, I would suggest, to be specific and also not to be unrealistic. One of the things that, if you look, one of the consistent factors that you see when you look at these cases, excuse me, even the successful cases, is that the case on quantum that's been set out by a claimant in terms of what they're seeking is almost always hugely out of proportion to what is eventually ordered. And usually the award is carefully targeted. Islet is something of an anomaly in that case. If in Nahajek, which is another similar case, it was a sum of money that was for paying for a training course to enable a particular job to be taken up. In another case, Rochford, which was successful. It was a sum of money that was to top up a pension to a given level, and so on and so forth. The idea of lifetime maintenance, or for example, the estate will buy you a house, if there's no context for that, is just nothing, is a non-starter. And I would suggest, and I've seen, for example, letters of claim which in an estate worth 1.5 million, they've said that our client has a claim worth 850,000 on the basis that, well, they need a house, they need therapy, they need this, they need that, they need the other. And you just think, well, they're never going to get that. And negotiating headroom is one thing, but setting out a case that is just asking effectively for the moon on a stick is going to cause defendants' attitudes to mediation to harden. And it's also going to render it difficult, I would suggest, to manage a claimant's expectations effectively, because if they see letters going out in their name that says 850,000, they are not going to necessarily happily accept that the award is maybe a tenth of that, even if that's what was going to be relevant. In terms of assessing claims, we've dealt with the point in relation to estrangement. There are a lot of cases out there recently. There are 4 of them named there, where estranged claimants brought claims and they just failed. Trials in Inheritance Act claims are very, very rare, to the point where I would be, it's worth bearing in mind, I would suggest, that many of the tribunals you might come in front of haven't actually done one before, if you discount situations like Masters. But consistently, claims where a claimant is effectively saying, I'm estranged from this person, but it was unreasonable for them not to make financial provision for me, have failed. And the situation in Islet and Nahajek is very much the exception in that case. And I've also referred there to the original district judge's decision being upheld in Islet. If the right factors are being borne in mind by a trial judge, an appeal is almost certainly going to be unsuccessful, unless it's so far off the reservation that it really can't be defended. But it is important to bear in mind that most of these cases do settle. So it's worth dwelling on that in terms of the way that these cases are done. They are usually mediated, aren't they, Hugh? And it's worth bearing that in mind.
I think, since we're running out of time, we should briefly mention the watch this space that is the Hirashand appeal.
Yes.
We scheduling this webinar, we hoped overly optimistically that the Supreme Court might sort of see fit to share its judgment in Hirashand with practitioners, but we're not there yet. And we've emphasised in this talk the role of CFAs in driving claimant-led, the number of claims brought in adult child claims. Well, depending on which way Hirashand goes, it could make a big difference to that sector of the market, because it makes the CFA arguable. If the decision of the Court of Appeal is to be upheld, it makes the risk in a CFA that much less, and the quantum in a CFA case, potentially, at least, that much more. Although if the Hirashand line of authority gets shut down by the Supreme Court, then that might have the effect of limiting the ambitions of CFA claimants. So that's a watch this space, and perhaps we'll be back with another webinar with fewer technical difficulties if and when that happens. But I see we are almost at 1 o'clock, so we possibly should draw things to a close.
Yes. On Hirashand, one small additional point. If you have a case going to trial during this interregnum between the decision being, or the case being heard and being handed down, as I had last month, you may well find a reluctance by a trial judge to deal with decision finally until Hirashand is handed down if there is a CFA issue, because they can affect the cases quite profoundly. In terms of, we've not had many questions, so we can draw things to a close there, save that there is one question that I would like to highlight, which raises the question about an absent parent during childhood, where the father purportedly said that he was busy working to build an empire so that the children wouldn't have to worry, but then left his estate to his spouse. I wonder, Hugh, if that's actually quite similar to a point you touched on during your remarks earlier, where it was about behavior of a parent.
Yeah.
It may be the case that a parent might have almost excused their absence by saying, don't worry, there is a point to all this, or something like that. But
I think, yeah, I want to, I'm going to get my authorities wrong here, but I think it was Mr. Justice Oliver in Coventry who emphasised that the awards under the Act are not rewards for good behaviour by a child, but neither are they compensation for bad behaviour by a parent. It's obviously not the case that's described in the question, but one thing one sometimes sees is 75 Act claims brought almost by way of compensation for alleged very serious bad behaviour by parents during childhood. And my instinct in response to claims like that is it's really not what the Act is for. It's not about righting past wrongs, and it's not about rewarding or punishing good or bad behaviour. It is simply about making reasonable provision for maintenance. And on its own, and obviously the question sets out a slightly different factual pattern, on its own, I don't think that mere bad behaviour by a parent is a good something more for an adult child claim. But the questioner kind of hints that there was a sort of estoppel type argument in that all this will be yours one day. And
yes,
maybe that gives you your something more, depending on your facts. And these are intensely fact-sensitive cases. But what
yes.
I would want to say is, don't think that the mere fact that a parent is an awful parent and that the child can set out a catalogue of poor behaviour during childhood, that is makes it a meritorious claim. I don't think that by itself is going to be enough.
I agree. Well, I think that's all we have time for. Thank you all for joining us. I'm sorry that we've had these difficulties with sound. I hope that it has been a useful and informative session nonetheless. As we've said earlier, the recording will be on YouTube, the notes will be, or the slides will be circulated. And as always, if there are questions, or if anyone would like to discuss something arising from this seminar, I'm certainly very happy to consider anything, or to take any calls or questions like that, and I'm sure Hugh is as well.
Absolutely, I'd repeat that, and also the apology for the technical problem, which seems to be entirely mine. So thank you so much for joining. It's good to see so many people here today. I hope the talk was useful, and maybe another one in the future, as and when Hiroshan gets handed down.
Yes, watch this space.
Watch this.
Thank you all.
Thanks very much.